Okay, let's unpack this. You've handed us a really fascinating stack of sources. We've got articles, research papers, analyses from places like the ACLU and the Heritage Foundation, even actual court filings.
Yeah, and they all seem to laser focus on one central thing: the current administration's approach to executive power, really since January 2025.
And honestly, the picture they paint is, well, pretty striking. It's one of rapid, often kind of confrontational change,
Mm-hmm.
a presidency that seems to be immediately pushing right up against, and sometimes, according to these sources, maybe past established legal lines.
What's really interesting looking through this material you shared is how it highlights this isn't just about, shifting policy here and there.
Right.
The sources are describing a more fundamental challenge, a significant tension between this administration's style of governing and what have traditionally been seen as legal norms, legal
It
limits.
feels less like tweaking the system.
Exactly. More like testing its very foundation.
Right. Exactly. And that's precisely our mission today for you. And we're guided entirely by the sources you've shared with us. We're going to dive deep into the legal criticisms and the constitutional underpinnings behind these actions.
We're basically here to pull up the core insights from this stack you've given us to help you make sense of the legal theories the administration seems to be using,
Yeah, what key actions are being taken?
why those actions are facing challenges in the courts and elsewhere, and, well, what the potential implications are, for separation of powers, the rule of law itself.
Think of it as understanding this constitutional stress test the sources keep mentioning, but without getting totally lost in the legal weeds.
Right. And importantly, we're exploring the analysis presented in these sources.
Impartially, of course. Our goal is really an engaging, insightful conversation that gets to the heart of what these documents are actually saying. Because, learning about even complex legal stuff should still be interesting. Maybe even a little fun.
Absolutely. And the sources really lay out a kind of clear structure, you could say, for this administration's approach to executive authority. It feels very deliberate. It starts with a specific theoretical foundation.
Which they trace in large part back to the unitary executive theory. Now, the sources describe this as a pretty robust, maybe even an extreme interpretation of that idea.
Right. Essentially, it's the belief that Article 2 of the Constitution gives the president total, undivided control over the entire executive branch.
This theory suggests that the president has, well, plenary control, meaning really broad, almost absolute control over the executive branch, and that Congress or the courts have very limited ability to check that control.
And for Fassung's blog, one of the sources you provided, describes this theory as championing the primacy of executive power, unshackled from constraints from Congress or even the courts. That's a direct quote.
Wow, unshackled.
Yeah. And what's particularly interesting, according to the Harvard Law Review piece here, is that recent Supreme Court decisions, especially their emphasis on exclusive presidential powers in certain specific areas, well, they might, perhaps unintentionally, be providing some doctrinal support, some legal precedent for these really expansive claims the administration seems to be making.
And this theory isn't just sitting in academic journals. The sources connect its practical application directly to specific policy blueprints we've seen surface, like Project 2025.
Yes, Project 2025. That's authored by the Heritage Foundation with a lot of input from former officials, apparently, and it's explicitly mentioned as a key roadmap.
Okay.
It outlines a whole strategic plan to fundamentally reshape the federal government, based squarely on this strong unitary executive idea.
And what does that mean in practice?
Well, it advocates for replacing significant numbers of career civil servants, the merit-based ones, with political appointees loyal to the president, often referred to as reinstating something called Schedule F.
Ah, Schedule F, right.
And also putting partisan control over agencies that have traditionally operated with some independence, like parts of the DOJ, the FBI.
The ACLU characterizes Project 2025 quite strongly in their analysis, doesn't it? They call it, I think, a roadmap for how to replace the rule of law with right-wing ideals.
They do. And the sources definitely note that individuals closely connected to Project 2025 are being appointed to key positions within the administration.
And Just Security adds that the executive orders we're seeing issued seem to frequently rely on these broad claims of inherent presidential power, sometimes even claiming a right or maybe an obligation to ignore or violate existing federal laws they see as problematic.
We do see historical parallels, of course. The George W. Bush administration also invoked the unitary executive theory.
Right, post 9/11 especially.
Exactly, particularly in the national security context. They used it to justify things like, warrantless surveillance programs despite laws like FISA or those controversial torture memos.
Yeah, John Yoo.
Well, where they asserted the president's commander-in-chief authority could override statutory prohibitions. John Yoo is definitely a key figure there.
Right, I remember that period. But do the sources suggest this is just like a repeat of the Bush years, or is something fundamentally different happening now?
That's exactly the key distinction the sources seem to draw. They suggest the Bush administration's use was often focused on specific, maybe more ad hoc, national security issues or justifications in a crisis context.
Okay.
This administration's approach, though, especially as laid out in Project 2025, appears to be a far more systematic, pre-planned, and fundamental restructuring of the entire executive branch, using this theory as the foundational principle.
So less about justifying one specific action during a crisis and more about like redesigning the entire furniture of government itself.
Precisely. The sheer scope of Project 2025, its detailed plans for reforming the civil service, consolidating control over agencies, ensuring ideological loyalty all the way down, it points to a much broader ambition. It's about fundamentally re-engineering how the executive branch operates.
Moving from using the theory for individual controversies to using it as the guide for how the whole executive branch should run across the board.
That seems to be the argument in the sources, yes.
And there's a specific concern raised in the sources about this intense emphasis on loyalty. What do they mean by that, and why is it seen as, well, potentially problematic?
Well, the sources argue that prioritizing loyalty to the president over those traditional civil service values like expertise, impartiality, loyalty to the Constitution and the law itself suggests a fundamental shift in what a civil servant's role is. It risks turning them into direct political agents of the president's agenda rather than, neutral implementers of laws passed by Congress.
Which, of course, challenges that core idea of a government of laws, not of individuals, and it could potentially erode crucial safeguards against hyper-politicization. Okay, so that's the theoretical grounding. How does this translate into concrete action? What methods is the administration primarily using, according to these documents?
Okay, moving from theory to practice. The sources clearly highlight one defining characteristic: an extensive, some might even say unprecedented, reliance on executive orders.
Right. The Verfassen's blog article amusingly calls it a battalion of executive orders.
A battalion, exactly, gives you a sense of the sheer volume.
And many of these orders, the sources say, aren't just minor tweaks. They aim for really sweeping policy changes.
And as the Just Security article notes, they frequently assert a kind of constitutional prerogative to ignore, disregard, or even openly violate federal laws.
So this preference for unilateral action, just bypassing the slower, more consensus-driven legislative process, that seems to be a hallmark.
It's certainly seen so, based on this material, and it has, quite predictably, led to a significant number of legal challenges right from the start.
The sources provide several key examples of this playing out in the courts, don't they?
They do.
Give us a couple of the most prominent ones mentioned.
Okay. One frequently cited example is the executive order that mandated the U.S. Election Assistance Commission, which is supposed to be an independent agency, mind you,
Right.
to require documentary proof of citizenship for voter registration.
That sounds like something Congress usually handles, or maybe the states.
Exactly. And voting rights groups like the Brennan Center and the ACLU, they quickly challenged this. They argued it was an unlawful power grab, usurping authority that belongs to Congress and the states, a classic separation of powers argument.
Okay.
They also argued the president lacks the statutory authority over the EAC specifically, and that the requirement itself could disenfranchise millions of eligible voters.
Then what happened?
According to the sources, a federal court had already issued a preliminary injunction, basically blocking the EAC from implementing that specific requirement for now.
So the courts are already stepping in to pump the brakes in some cases?
In that instance, yes.
Yeah.
Another area where executive orders are being used aggressively is environmental regulation.
Ah.
Sources mention the EO, titled Unleashing American Energy, which directed the outright repeal of long-standing NEPA implementing regulations. NEPA's the National Environmental Policy Act.
So basically dismantling a nearly 50-year-old legal structure for environmental review.
That's how critics frame it.
What was the stated reason for that? And the criticism?
Well, the stated goal was speedy reviews for infrastructure projects.
Hmm.
But critics, as detailed in the sources here, argue it significantly limits the consideration of important factors like cumulative environmental effects, climate change impacts,
How?
by restricting the scope of analysis to only effects with a reasonably close causal relationship. It's seen as a way to fast-track projects by, well, limiting the environmental scrutiny required.
Executive orders are also being used, the sources note, to try and restructure federal agencies and the civil service itself, things like attempting large-scale reductions in force. Mass firings, basically.
Hmm.
And bringing back that Schedule F we mentioned earlier, converting career jobs to at-will employment.
Yes, and perhaps one of the most unusual, let's say, example cited is the reported creation of a U.S. DOGE service.
Wait, DOGE, like the internet meme, the dog.
Yes, like the cryptocurrency mascot,
Yeah.
allegedly placed under the control of Elon Musk and making decisions about funding and personnel without clear legal authority from Congress.
A U.S. DOGE service under Elon Musk. That sounds unconventional, to put it mildly. What do the legal challenges say about that specifically?
It certainly caught the attention of the sources, as you can imagine. The Campaign Legal Center, for instance, condemned this as an unconstitutional overreach. They specifically called it an affront to Congress's powers of appropriation and oversight.
Meaning?
They argue it attempts to bypass the established constitutional process for funding and managing government functions, which, rests squarely with Congress.
Okay, that makes sense. It's not just that it's weird, it's allegedly trying to spend money and hire people without Congress having explicitly said, okay. Now, in terms of the sheer volume of EOs, the sources do note a historical parallel with FDR, right? He used over 3,700 executive orders during the Depression and WWII.
That's true. And some of his orders also faced challenges. The Supreme Court struck down certain NIRA-related orders in the 1930s for improper delegation of legislative authority to the executive. So that period definitely shows the judiciary acting as a check.
Absolutely. But what's the crucial distinction the sources draw here between FDR's use and what's described now?
It seems to be about the purpose behind the orders. The sources argue that these current EOs aren't simply implementing policy within the existing legal framework.
Mm-hmm.
Instead, they're being used to assert novel, really expansive interpretations of presidential power itself, effectively trying to unilaterally reshape constitutional understandings like on birthright citizenship or fundamental voting procedures by bypassing the slower legislative process or, the process for constitutional amendment.
So it's not just executing the law as written, it's attempting to make new constitutional law or override existing statutory law directly through executive action.
That's the core criticism raised by the sources, yes. And the legal landscape itself is actually shifting in ways that might impact this strategy, particularly with the Supreme Court's significant 2024 decision in Loper Bright Enterprises v. Raimondo.
Ah, yes, the case that overturned Chevron deference.
Exactly.
Chevron deference. That was the principle where courts generally deferred to a federal agency's reasonable interpretation of an ambiguous statute, right? If Congress wasn't crystal clear.
Precisely. And the Brookings Institution analysis you provided points out that this decision could, perhaps even unintentionally, weaken the administration's ability to implement its broader regulatory agenda unilaterally through agency action.
Oh, so?
Because lower courts are now freer to scrutinize and potentially block agency interpretations and actions without giving them that default deference.
Huh. So a victory for conservatives wanting to curb the power of the administrative state could paradoxically constrain a conservative president trying to use that state for their own agenda. That's fascinating.
It creates a real tension, doesn't it? Overturning Chevron means the court asserted its own role, and that of lower courts, to find the single best meaning of a law, rather than just accepting an agency's permissible interpretation.
Right.
And while the Supreme Court had already been backing away from Chevron, it was still very influential in lower courts. Its demise is likely to make it harder for the administration to defend agency actions when they get challenged there.
This might push the administration towards relying even more heavily on direct executive orders then, especially those based on claims of inherent executive authority, rather than going through the agency rulemaking process, just to try and bypass that heightened judicial scrutiny on agencies.
The sources suggest that's certainly a potential outcome. But despite this potential roadblock, the administration has also shown a consistent strategy of actively engaging the judiciary, particularly by frequently seeking emergency relief from the Supreme Court.
This is often referred to as using the shadow docket, right?
Exactly. The sources note that in the first Trump term, The Justice Department sought emergency relief over 40 times, reportedly 20 times more than the Bush and Obama presidencies combined.
Wow.
And this aggressive use has apparently continued under the current administration, according to these materials.
And the strategy seems designed to leverage the current Supreme Court composition to get quick, favorable outcomes on controversial policies, sometimes bypassing the slower, more deliberative process of full lower court review, evidence gathering, appeals, all that.
It appears to view the Supreme Court not just as the final judge of legal disputes, but sometimes as an early-stage facilitator of the administration's agenda, especially when lower courts have ruled against them.
And the critics.
Critics in the sources argue this risks distorting the traditional appellate system. It reduces transparency because these decisions often come without full briefing or oral argument, and it can potentially undermine the perceived legitimacy of outcomes decided this way.
It's a departure from past practice, where the emergency docket was generally reserved for genuinely exceptional, really time-sensitive situations.
That's the argument presented, yes.
Okay, let's turn to how the administration's approach, as described here, is creating friction with fundamental principles like the rule of law and the separation of powers. One area the sources highlight intensely is the administration's conduct towards the judiciary itself and, interestingly, towards the legal profession.
It's described as a very assertive, often adversarial posture that seems to go beyond typical courtroom disagreements.
How so?
The sources mention the White House explicitly articulating a policy of holding attorneys and law firms accountable for what it terms illegal or unethical conduct, particularly when they engage in litigation against the government or pursue what the administration labels baseless partisan attacks.
And there was a presidential memorandum reported, right, instructing the Attorney General to prioritize seeking sanctions against such attorneys.
Yes, and even recommend reassessing security clearances or terminating federal contracts for lawyers whose conduct is deemed sanctionable by the administration.
And the sources cite specific examples where this isn't just talk.
Correct. Several prominent law firms are mentioned as facing punitive actions, things like having security clearances revoked or being debarred from receiving federal contracts. And some of these firms have actually sued the administration in response.
And the American Bar Association, too.
Yes, the ABA also reportedly filed a lawsuit after its grants for domestic violence. Legal services were canceled shortly after a DOJ memo singled it out for its support of activist causes and litigation against the government.
So the sources suggest a pattern here. Using government power, things like contracts and security clearances, to target and penalize legal entities, specifically because they are seen as adversarial or challenging the administration's agenda. That feels like a significant step beyond the usual adversarial relationship in court.
Absolutely. It seems to move beyond simply defending policies in court to actively using other levers of government power to potentially penalize and, frankly, deter legal opposition.
The formalizing of this policy is seen in the sources as a real departure from previous administrations.
Yes, and it carries a substantial risk of creating a chilling effect, potentially making lawyers and organizations hesitant to take on cases against the government for fear of reprisal.
Which directly challenges how the adversarial system is supposed to function and raises serious First Amendment concerns about the right to petition the government, access to justice.
Precisely.
Beyond targeting lawyers, the sources raise very serious concerns about alleged noncompliance with judicial orders. What do they say there?
Yes, the ACLU has voiced significant concerns about a serious risk that the administration may simply choose to ignore court defeats or rulings it disagrees with.
Are there specific examples cited?
Specific examples mentioned include alleged failures to fully halt deportation flights under that archaic Alien Enemies Act, despite temporary restraining orders being issued, and alleged failure to secure the return of an individual deported, despite court orders explicitly prohibiting that deportation and requiring their return.
The Verfashions blog piece also reports on a tension where, while the government lawyers in court claim compliance, individuals directly affected reportedly testify in court that the enjoined actions are still being enforced, sometimes to the point where one judge reportedly suspected the government of making untruthful representations to the court about its compliance.
The Migration Policy Institute also highlights active concerns regarding adherence to judicial orders, particularly in complex areas like deportations.
And if substantiated, if these instances become widespread, what's the implication?
Well, alleged noncompliance strikes at the very heart of the judiciary's co-equal status in our system. It could, as some sources suggest, precipitate a constitutional crisis by directly undermining the authority of court rulings.
We've certainly seen presidents clash with the judiciary before. Nixon and Watergate?
Right, U.S. v. Nixon. The Supreme Court unanimously rejected his executive privilege claim, famously affirming the president is not above the law.
A landmark case.
And further back, Andrew Jackson's administration famously proceeded with the forced removal of Native American tribes, despite Supreme Court rulings like Worcester v. Georgia that should have protected them.
A tragic example.
It illustrates a historical instance where executive policy effectively overrode judicial pronouncements, and, tragically, the rights of a minority group.
But this explicit policy of targeting law firms and legal organizations specifically for challenging the administration, that does seem novel and particularly concerning based on these sources.
It risks degrading the standing of the courts and legal processes themselves, potentially moving towards a system where legal challenges are met not just with legal arguments, but with punitive sort of extrajudicial measures.
The sources also extensively discuss contested boundaries between executive and legislative authority. They note actions perceived as directly encroaching on Congress's constitutionally assigned powers.
Yes, particularly executive orders that aim to restructure or assert unprecedented control over independent regulatory agencies.
Like requiring independent agencies, the FCC, to submit proposed rules for White House review and approval.
Exactly. Critics see that as deliberately undermining their congressionally mandated independence and impartiality.
Or that controversial U.S. DOGE service we talked about earlier.
Right, allegedly making funding and personnel decisions without clear statutory authorization from Congress. That was condemned specifically as a usurpation of Congress's powers of appropriation and oversight.
And Fasten's blog points to other orders reportedly directing the cessation of payments for certain congressionally authorized programs,
which is seen as a direct challenge to Congress's fundamental power of the purse, the power to decide how federal money is spent.
The legal justifications for these actions, the sources say, seem to draw heavily from those formalist interpretations of exclusive presidential powers we mentioned earlier.
Yes. The Harvard Law Review piece highlights that recent Supreme Court rulings identifying some presidential powers as exclusive can be interpreted by the executive branch as effectively disabling Congress from acting or regulating in those same areas.
How so?
The administration seems to apply this idea very expansively, implying that if the executive has any power in a particular area, then Congress is effectively locked out from regulating it, which kind of minimizes the long history of shared or overlapping powers between the branches.
The Youngstown Sheet and Tube Company v. Sawyer case, the famous steel seizure case, is a critical historical benchmark here, isn't it?
Absolutely foundational. In that case, the Supreme Court struck down President Truman's seizure of steel mills during the Korean War.
And what was the key principle?
Stating unequivocally that presidential power must come from either an act of Congress or the Constitution itself. It can't just be conjured out of thin air. Justice Jackson's famous concurring opinion provided that three-tiered framework for analyzing presidential actions.
Right, based on whether they align with, are independent of, or go against Congress's expressed will.
Exactly. And Youngstown remains a cornerstone for assessing executive actions taken without or in defiance of congressional authorization.
And the sources argue that the current executive orders, particularly those claiming inherent power to override statutes or direct agencies contrary to statutory mandates, directly challenge this core principle established in Youngstown.
That's the argument. And this ties into a fundamental challenge raised in the sources about the president's constitutional duty to take care that the laws be faithfully executed.
Traditionally, that clause has been understood to mean the president must enforce all constitutionally valid laws duly enacted by Congress.
Right.
If the executive branch disagreed, the proper course was legislation or a veto.
Right. But the administration's asserted prerogative to simply ignore, disregard, or even actively violate statutes it disagrees with, often based on those broad claims of inherent executive power. Well, it suggests a belief that faithful execution can somehow include suspending or nullifying laws if the president decides they interfere with his agenda or vision.
Effectively casting the president in a law-interpreting, even law-nullifying role that's usually reserved for the courts or Congress itself.
Which fundamentally alters the intended separation of powers and the principle of legislative supremacy.
Concerns about the rule of law also extend deeply into the integrity of federal law enforcement and administration, according to the sources. The Campaign Legal Center, for instance, speaks of unprecedented levels of manipulation within the Department of Justice.
Allegations cited include dismissal of career employees seen as disloyal, termination of lawsuits against political figures perceived as allies,
Abandonment of voting rights cases.
and allegedly initiating investigations against perceived adversaries of the administration.
And Project 2025 reinforces this.
Explicitly, it advocates for a DOJ and FBI director who would be under much closer White House control and explicitly aims to empower the DOJ to prosecute political rivals.
The ACLU's analysis also notes the abandonment of federal police oversight initiatives, like rescinding consent agreements with police departments and retracting findings of systemic police abuse.
These actions, taken together, strongly question the DOJ's independence and its commitment to impartial law enforcement, free from partisan influence, according to these critics. Nominating individuals perceived as highly aligned with the president's political agenda to key DOJ leadership positions further signals this intent.
And parallel concerns exist about the nonpartisan civil service as a whole, that proposed reinstatement of Schedule F.
Right, converting tens of thousands of career positions to at-will employment based explicitly on loyalty to the president rather than merit or expertise. That's highlighted as a central element of this effort.
Lawfare highlights how the broad discretion presidents traditionally have in personnel matters poses a significant threat to the very concept of a neutral professional civil service.
Which aligns perfectly with Project 2025's stated goal of dismantling what it sees as an entrenched bureaucracy and replacing it with individuals ideologically aligned with the administration. The dismissal of inspectors general, who serve as internal watchdogs, is also cited as undermining internal checks and balances.
So the sources are presenting this not as a few isolated incidents, but as a conscious, systemic effort to dismantle institutional independence across vast swaths of the executive branch, actively seeking to replace professional autonomy and merit with direct presidential control and partisan allegiance.
That's the picture painted, yes. Which, if successful, moves the system towards a highly centralized, personally directed model of government, inherently undermining the checks and balances designed to prevent abuse of power and ensure accountability to the law and the public, rather than just the chief executive.
These broad legal and constitutional approaches seem to play out particularly acutely in specific policy domains. Immigration is clearly one major area where this is visible in the sources.
Yes. Immigration policy has been a central focal point for the administration's assertive use of executive power, consistently testing legal and constitutional limits according to these analyses. A key piece of the rhetoric, and reportedly the legal justification for certain actions, is characterizing the current levels of migration at the southern border as an invasion.
Sources like ProPublica detail this as a fringe legal theory, right, outside the mainstream of constitutional scholarship.
That's what they report. The consensus among legal scholars, according to these sources, is that current immigration levels simply do not meet the definition of an invasion as understood in the Constitution's Guarantee Clause.
And courts have weighed in.
At least 4 federal judges have explicitly ruled against this interpretation, the sources note.
Yet, this invasion rhetoric is reportedly the primary legal justification the administration is using to invoke the Alien Enemies Act of 1798.
Yes. An archaic wartime statute dating back to the Quasi-War with France. The administration is reportedly using this act to deport certain individuals, like Venezuelans allegedly to El Salvador, bypassing standard immigration due process procedures.
And these actions are facing numerous legal challenges, I assume.
Absolutely. The ACLU, among others, has secured preliminary relief blocking some of these deportations under the Alien Enemies Act. The Supreme Court itself has ordered that individuals designated as alien enemies must at least be given notice and an opportunity to contest that designation before being deported under the act.
And scholars cited in the sources also point out that the power to suspend habeas corpus, the right to challenge detention in court, generally rests with Congress, not the president alone.
Correct.
Constitutional questions also arise from the reportedly considered or possibly issued executive order seeking to redefine birthright citizenship.
Yes, critics universally call this an unconstitutional attempt to unilaterally alter the meaning of the 14th Amendment and override existing statutes governing citizenship.
They argue it's a clear executive attempt to reshape the electorate and national identity outside of the constitutional amendment process or legislative action.
That's the core of the criticism. The sources indicate courts have either blocked or slowed this effort, and the Supreme Court has reportedly ordered oral arguments on related questions.
Just Securities analysis suggests this Secker O attempts to overrule an entire statutory regime on citizenship without even acknowledging the existing laws it would contradict.
Other policies leading to significant legal battles mentioned in the sources include mass deportation efforts, sweeping overhauls of the asylum system, shifting towards much narrower convention against torture screenings, for example, expanding extradited removal procedures.
And rescinding previous guidelines protecting sensitive locations like schools and hospitals from enforcement actions.
International students have also reportedly been targeted, with visa cancellations based on speech or minor infractions, which the ACLU has challenged on First Amendment and due process grounds, leading to some government reversals in specific cases.
Historical analogs here are pretty potent warnings, aren't they? Korematsu v. United States.
Yes, upholding Japanese-American internment during WWII based on perceived military necessity, despite powerful dissents and the conviction later being overturned due to government misconduct. It stands as a stark warning about executive overreach and discrimination in times of perceived emergency.
And President Lincoln's suspension of habeas corpus during the Civil War, despite Chief Justice Taney's ruling in Ex parte Merriman that only Congress possessed that power.
Another classic example of executive power clashing directly with judicial review during a crisis.
So the administration's strategy here, based on the sources, seems to be instrumentalizing archaic laws and embracing fringe legal theories, like the invasion concept, to achieve contemporary policy goals.
That's how it's presented. In this case, drastically curtailing immigration and accelerating deportations. Using the Alien Enemies Act from 1798, or the invasion theory, applies legal frameworks far removed from their original wartime context to current migration patterns.
And that allows actions like deportation without standard due process, framing immigration not just as a policy challenge, but as an extraordinary military or national security threat. It's an effort to find, or maybe create, legal loopholes to get around established legal protections.
That appears to be the interpretation in these sources.
Mhm.
There's also evidence, according to the sources, of blurring the lines between foreign policy and domestic immigration enforcement, potentially to shield actions from stricter domestic scrutiny.
How so?
Deporting Venezuelans to El Salvador under the Alien Enemies Act, for instance, was partly justified by alleging they were gang members directed by a foreign president, framing what many see as a domestic immigration issue as a foreign national security threat.
And the student visa revocations based on speech deemed to have potentially serious adverse foreign policy consequences. That uses a foreign policy rationale to target individuals within the U.S. for their expression.
Right. By framing actions as responses to foreign threats or inherently implicating foreign policy, the administration may be attempting to leverage the broader deference traditionally given to the president in those specific areas.
To insulate these actions from more stringent domestic legal constraints and judicial review, potentially at the expense of individual rights and due process.
Exactly.
Civil rights and liberties are another area seeing significant legal challenges under this administration's approach, particularly focusing on DEI initiatives, transgender rights, and federal oversight of law enforcement, as highlighted in the sources.
The administration is actively rolling back diversity, equity, and inclusion, or DEI initiatives across federal agencies and contractors through executive directives.
And the ACLU has challenged this.
Yes. For example, they reportedly successfully blocked a Department of Education letter that threatened to defund institutions over their DEI programming, and guidance that required states to certify schools weren't supporting DEI efforts.
These actions, the sources point out, align directly with Project 2025's call to terminate all DEI programs government-wide and to shift the DOJ's focus to prosecuting what it terms anti-white racism.
Proponents frame this as combating state-sanctioned racism, but critics in the sources see it as a significant regression in civil rights enforcement and priorities.
Executive actions targeting transgender rights have also seen considerable legal contestation.
Yes, the ACLU has reportedly blocked an attempt to ban gender-affirming health care for individuals under 19 via executive action, challenged an EO regarding passport sex markers, and is challenging the administration's approach to the military ban. These actions seem to reflect a policy agenda explicitly promoted by Project 2025 as well.
And in the realm of law enforcement,
The sources indicate a significant shift away from federal oversight of local police departments, including abandoning previous initiatives and rescinding consent agreements aimed at addressing systemic misconduct.
this withdrawal, some sources argue, aligns with a push towards what critics call militarized and unaccountable policing, perhaps suggested by the title of an EO aimed at strengthening and unleashing America's law enforcement.
That's the connection some critics draw. It contrasts sharply with past administrations, including conservative ones, that use DOJ investigations and consent decrees as tools to address systemic patterns of unconstitutional policing.
It sounds like the administration's approach to civil rights, based on these sources, involves a fundamental redefinition of what discrimination is, shifting focus away from historically marginalized groups and systemic inequalities towards addressing grievances related to perceived anti-white racism and actively dismantling DEI initiatives.
The call within Project 2025 for the DOJ to prioritize prosecuting anti-white racism, coupled with pulling back federal police oversight that often impacts minority communities disproportionately. Well, it strongly indicates this reorientation, according to the analyses.
It suggests an ideological shift.
Potentially using civil rights enforcement tools to advance a counter-narrative that de-emphasizes systemic discrimination against traditional protected classes.
And the potential consequence, as outlined in the sources, is that this could weaken federal protections for vulnerable populations and redirect enforcement priorities in a way that risks reversing decades of civil rights progress.
hmm Executive power is also being used assertively in economic and foreign policy arenas, raising additional legal questions and challenging established international frameworks, according to the sources provided.
In trade, the executive order imposing reciprocal tariffs and broader tariff hikes are cited as disrupting global supply chains.
Right. While specific challenges to the current administration's 2025 tariffs aren't detailed in this material you gave us, the sources do note that first-term tariffs face significant challenges over whether the president had exceeded his delegated authority under various trade statutes.
Questioning the procedural basis and criteria used, like invoking national security to justify tariffs on allies.
Exactly. On foreign policy, the administration's posture towards long-standing alliances like NATO raises constitutional questions, according to Lawfare.
How so?
They note that Congress has passed legislation attempting to bar a unilateral presidential withdrawal from NATO, but the legal mechanisms for enforcing such legislation are complex and potentially untested.
So it highlights that inherent tension between the president's broad foreign affairs powers and Congress's powers over war, armies, and treaties.
Precisely. And Verfassem's blog specifically highlights concerns about executive orders that could, quote, trash treaties, abandon international assistance, and upset longstanding international alliances.
These actions in trade and foreign policy seem to demonstrate a willingness, outlined in the sources, to unilaterally disrupt or potentially withdraw from established international agreements and frameworks.
Yes. This approach relies on broad interpretations of executive power, potentially overriding congressional intent or existing treaty obligations. The unilateral imposition of tariffs and the concerns raised about a potential NATO withdrawal are prominent examples of this impulse described here.
And collectively, they challenge the traditional balance, where Congress plays a significant, constitutionally mandated role in foreign commerce and matters related to treaties.
The administration, as described in the sources, may be leveraging perceived ambiguities in the law or asserting broad inherent authority to act independently in these areas, leading to unpredictability for allies, potentially weakened international frameworks, and increased conflict between the branches here at home.
To fully grasp the legal and constitutional significance of this administration's approach, the sources consistently say we need to place it within the broader historical trajectory of presidential power in the U.S.
Right, and the sources generally describe it as a more overt, systematic, and ideologically driven challenge to establish norms and constraints than most predecessors.
Often calling it something like a unilateral presidency on steroids, arguing this has been amplified in the current term.
Just Security argues the assertion of a roving authority to override or simply ignore binding federal legislation represents a significant departure from historical practice.
While presidents have certainly expanded their power over time, the sources suggest the current administration seems uniquely willing to proactively define crises or situations in ways that specifically justify its predetermined assertion of expansive power.
Like using the invasion rhetoric to justify actions under an archaic wartime act. Yeah.
And the sheer scale and ambition of the pre-planned restructuring outlined in documents like Project 2025, aiming to centralize power and ensure ideological conformity throughout the executive branch. That's described in the sources as unprecedented in its comprehensiveness compared to previous transitions.
And that explicit formalized policy of potentially targeting the legal profession and organizations for opposing the administration's agenda, that's seen as a novel and deeply concerning development.
The volume of executive orders used to enact fundamental policy shifts, rather than just implement existing laws, is also noted as particularly high compared to recent presidencies.
Yet there are certainly parallels to draw upon from history, as you mentioned earlier. Assertive or even aggressive use of executive power has been seen in strong presidents during periods of perceived crisis or transformation.
Figures like Andrew Jackson, Abraham Lincoln, Teddy Roosevelt, Woodrow Wilson, FDR.
Exactly. And conflicts with the other branches, particularly the judiciary and Congress, are also not new.
Jackson's clash with the Supreme Court over Indian removal, Lincoln suspending habeas corpus despite Chief Justice Taney's ruling, FDR's court packing attempt,
All historical examples of profound interbranch tensions over the limits of presidential power.
and the unitary executive theory, as we discussed, finds a precedent in the George W. Bush administration.
Although arguably, as the sources note, it was less systematically applied then, perhaps more focused on specific national security justifications post 9/11.
And while outright defiance of Supreme Court rulings is historically rare, the allegations of noncompliance with lower court orders cited in the sources, if proven widespread, that would certainly place this administration in a controversial historical category.
Drawing parallels, perhaps, to instances like Jackson in certain cases, or Lincoln's response to the Merryman decision during the Civil War, yes.
One of the major concerns raised repeatedly in the sources is the potential long-term institutional impact of this overall approach.
Efforts to undermine civil service independence, politicize the DOJ, normalize overriding statutes via executive action, and the potential for disregard for judicial orders. These could severely erode public trust in government institutions and fundamentally weaken the rule of law over time.
Susan Hennessy and Benjamin Witz, in their work Unmaking the Presidency, referenced in the sources, argue persuasively that the very idea of the presidency itself as a public trust bound by law, norms, tradition, is actively being fundamentally remade by this approach.
A key pattern the sources identify is what's sometimes called constitutional hardball, pushing the formal legal powers of the presidency to their absolute limit while simultaneously disregarding the unwritten norms of restraint, interbranch respect, and procedural regularity that have historically guided presidential conduct.
Because many presidential powers are shaped as much by long-standing practice and these informal norms as they are by the actual text of the Constitution itself. Right.
Exactly. Actions like issuing expansive executive orders that seem to contradict existing statutes, the aggressive and often opaque use of the shadow docket, the reported policy of targeting perceived legal adversaries, allegations of noncompliance with judicial orders.
These all represent a significant departure from traditional forms of presidential self-restraint and respect for institutional boundaries.
That's the argument. The baseline seems to shift to anything not explicitly prohibited by a court right now is permissible, and norms are irrelevant if they impede the administration's agenda.
And if this approach becomes a sustained norm in presidential conduct, what do the sources warn about?
It could lead to a much more confrontational, unstable, and unpredictable system of government. The informal guardrails of democracy, many built on these unwritten norms and mutual respect between branches, could face systematic dismantling.
The presidency itself could become far more powerful in practice, not through formal constitutional amendment, but by eroding those informal checks and balances that have developed over centuries.
And given the approach described in the sources towards Congress and towards internal executive branch checks like the civil service and inspectors general, the judiciary is increasingly being positioned, perhaps reluctantly, as the principal, maybe even the sole, institutional check on executive power.
Which puts immense pressure on courts to resolve fundamental political and constitutional questions that might ideally be worked out through negotiation or the legislative process.
And over-reliance on the courts for this purpose can itself politicize the judiciary and strain its capacity. The sheer volume of litigation challenging the administration's actions, detailed in the sources, is really a testament to this strain.
And if the judiciary is perceived as failing to effectively constrain executive overreach, or if its orders are allegedly disregarded,
the entire system of checks and balances could be fundamentally undermined, potentially leading towards a more unchecked executive power in the future.
So this deep dive into the sources makes it pretty clear that the administration's approach, as described here, represents a significant systemic challenge to established constitutional norms and the traditional balance of power.
It's doing this through aggressive unilateral action, and by constantly pushing the boundaries of legal and constitutional interpretation, according to the analyses you provided.
But it's also true, and the sources show this too, that there is significant resilience built into the system. You see an active judiciary at multiple levels.
District courts issuing injunctions, the Supreme Court hearing arguments.
You see active legal challenges being brought by civil society organizations, leveraging those legal processes. Courts are actively scrutinizing the administration's actions based on what we've read here.
Yet simultaneously, the sources highlight significant vulnerabilities. These include the system's heavy reliance on those unwritten norms that are now being systematically disregarded, the potential for executive noncompliance with court orders, and the strategic, perhaps novel, use of the courts themselves, particularly the Supreme Court's emergency docket, by the administration to advance its agenda. It's not a static picture. It's a dynamic legal and constitutional battle playing out in real time.
And the sources prompt us to reflect on the potential long-term impact. If this approach, characterized by pushing boundaries and disregarding norms, becomes a sustained norm itself for future presidencies.
It could fundamentally alter the nature of the American presidency, potentially making it significantly more powerful and less accountable in the future, impacting the separation of powers, the rule of law, even the protection of fundamental rights.
This deep dive into the sources really raises an important question for all of us to consider, doesn't it?
I think so. Given how much of the American system relies not just on codified laws in the text of the Constitution, but also on unwritten norms, traditions, and mutual restraint between the branches, things not strictly enforceable in a court.
Yeah.
What does it mean for the future when a presidency explicitly chooses to operate outside of those norms? How do those informal guardrails withstand systematic challenge? And, well, what happens to the system if they erode?
Definitely something to think about based on the fascinating and frankly quite challenging material you shared with us today.